This week we're going to be looking at implied terms, whereas last week we looked at express terms, and it was at least relatively easy because these were the terms that were actually expressed either through speaking or through writing. Implied terms are more difficult because, as the name suggests, they are actually implied into the contract without necessarily being written down or said by the parties. There are a number of ways in which terms can be implied, and so that's where we're going to start.
One of the important things to understand about contracts and contract law in general is that these contracts don't stand in isolation. Rather, they're part of a broader relationship between the parties, and it's important to understand the context within which they exist. This is especially true in the commercial sector, where particular industries or areas of business might have ways of doing things, and it's important to understand that so that we can really fully understand the contract in its context. With that in mind, the first way that terms can be implied into a contract is through custom. And this is the idea that certain industries will just have customs that will be implied into contracts. Obviously, this is not going to be true of all contracts across the world, but rather particular industries will just have ways of doing things, and even though the parties might not express that way of doing things within the contract itself, it doesn't change the fact that there is a reliance upon that custom, and that is a custom that can then be relied on as an implied term before the courts. The example that I've put there is from Hutton and Warren, dates all the way back to 1836. And it's the idea that within a farming context there were certain customs at that particular time which were relevant, and even though they weren't included in the express terms of the contract, they were successfully relied on within the courts because of the implied custom between the parties. In a more modern sense, you're likely to see this in areas like shipping law, where although a lot of the terms will be sort of written down, it might be the case that there are still going to be some implied terms between the parties that are especially relevant in shipping law. The important thing to note about customs and also implied terms in general is that they're not going to override the express terms of a contract, and this is an idea that dates all the way back to that 1919 case of Les Affréteurs Réunis Société Anonyme and Leopold Walford Ltd, and can actually be expressed in a rather nice Latin phrase, which is Expressum facit cessare tacitum, or that which is expressed renders what is implied silent. So if the parties have expressly overrided a custom of a particular industry, then obviously the parties cannot then rely on that custom and go against the express terms of the contract. The next way in which terms can be implied into a contract is through statute, and this often sort of comes from custom, and then as customs become more common or knowledgeable across the country or between the parties, it's often at this time that Parliament will step in and enact those customs into statutes. It's also relevant that Parliament will sometimes step in order to protect certain vulnerable groups. So you'll see a lot of like employment legislation and sale of goods legislation as well, where there is a disparity between the parties in the contract. The employer is more powerful than the employee, the seller is often more powerful than the buyer, and so Parliament will step in, it will enact a statute to imply terms into a contract in order to protect the more economically vulnerable party in that relationship. The third and final way in which terms can be implied is via the courts, and so the courts can actually step in and imply terms themselves, but again this is important to note that they shouldn't be going against the express terms of a contract. There are actually many areas in which the courts have implied terms in order to meet what might be considered reasonable expectations. This comes to the idea that when we're implying a terms, or when the courts are implying a terms, the judge doesn't really have like a free rein to imply whatever they think is fair. It's really all about what the parties would consider to be a reasonable expectation themselves, or what the parties would certainly have agreed on if you'd asked them the question before they actually went into the contract. For example, we have employment law there in Lister and Romford Ice, and the idea here is that an employee should exercise reasonable care when doing their job. So this is a perfect example, really. What we have here is the idea that it's something that you would expect from an employee anyway, but you wouldn't necessarily put into the employee's contract that they should use reasonable care. You would just expect it as a matter of course. So it was okay for the courts in that situation to imply that term into the contract. Similarly, in landlord and tenant law, Liverpool City Council and Irwin, we have this case here where there was a block of flats and the council didn't do anything to maintain the common areas. So often the lifts were broken and the stairs, were unusable. And it often meant that people really just struggled to get access to their own property. And the implied term here was that the council should actually maintain these common areas. Again, it's something that is not necessarily expressed in the contract itself, but there's a reasonable expectation of the parties that the council is actually going to maintain the common areas of its own building. The courts can also imply terms in order to remedy a failure of expression. The idea here is that you're giving business efficacy to the contract, and it must have been intended by the parties. This is coming back again to the similar idea about if you ask the parties before they started the contract if they would have agreed to a particular term, if they would have said, yes, of course we would agree to that, it's just so obvious we wouldn't actually express it in the contract, then it's okay for the courts to imply a term in that context. We've got that quote from Lord Justice Bowen in the Moorcock. Moorcock is an interesting case. The idea here was that they were looking after a boat for a particular person, and the levels in the river, the tide actually went down. This ended up causing damage to the boat, and there was a question about whether the party that was looking after the boat was responsible for that. Obviously they argued that, well, we're not responsible for the tide going down and stuff like that, but there was a reasonable expectation that they would take good care of the boat and be aware that there were tides on the River Thames. So it was implied into the contract that they wouldn't damage the boat or would look after it when the tides actually went down. Now, there is a bit of an open question in this context about what should happen when the term appears obvious but might have been against the interests of one of the parties. A bit of an interesting question here. It's worth looking at the judgment of Lord Hoffman in that Belize case from 2009. It's a Privy Council case, so maybe not as authoritative as a House of Lords case might have been or a Supreme Court case nowadays. But nevertheless, it's worth looking at, and that idea of objectivity is maybe something that might come up as part of an essay question. So worth looking at that case if it does come up in that context. And finally, it should be noted that a contract can expressly exclude implied terms, as we know that idea that the express terms will override them. But this has to actually be clear. So if you're saying there are not going to be any terms implied into this contract is the only thing that matters, then obviously that's a pretty clear exclusion of implied terms in general. And that's actually something that parties will sometimes do to get away with things. Obviously they can't exclude terms that are implied by statute, because that's obviously a different thing, but they can prevent the courts from implying a term into a contract if they actually express it themselves. The reason that that has to be extremely clear is because the courts will try and imply a term into the contract to actually sort of help the parties get to what they think that they actually mean themselves. So in Johnston and Bloomsbury Health Authority, one of the issues that came up was that the junior doctor in this particular case was working, a horrendous number of hours a week, and it was actually unsafe for them to do so at that particular time. It was just so many hours. They were often relying on sort of maybe 3 or 4 hours night sleep a week, and a day, and it was just becoming completely unsustainable. So they brought this case, and there was an attempt to exclude the term that there was a safe working place because of the amount of hours that the junior doctor was required to work. And the courts generally rejected this as sort of like excluding the implied term of a safe workplace, unless it was expressly excluded by the health authority, then there was no way that they could argue that the number of hours required by the junior doctor to work would actually sort of exclude other terms of the contract. That was allowed to stand on its own, and so the requirement of a safe workplace, which again is something that would be relatively obvious between the parties in an employment context, that was allowed to stand.
And there we have implied terms. I think that one of the real issues in this area, especially for students who are maybe dealing with a problem question, is that the introduction of implied terms into a given scenario is not really going to be very obvious. After all, with express terms, it's easy to see what the parties said or wrote down, whereas with implied terms, we're sort of thinking about what could be implied by custom within this particular industry, or what are the statutes or the courts likely to include. Therefore, I think that when you're approaching this question, I think that one of the main things to think about is what the claimant in a particular contract case is after, and whether what they think should have happened within a contract has actually happened, and if not, whether a term could be implied into the contract so that the claimant gets what they want. Now, do remember you have to be very careful. It's not just a straightforward case of implying any term you want into a contract. It has to be something that is relatively obvious and that both parties would likely agree on at the start of the contract. It's just that they didn't put it down into words. Well, that's all from me this week. I'll be back in the future with more stuff on contract law, so do subscribe to the channel if you're interested in finding out more about that, especially if you're a student in this area. If you've got any questions or comments, then leave those below, and I always appreciate likes on the video as well. I'll be back soon, but for now, bye!